and welcome to In Parliament. I'm Sharon Tong. A heartfelt tribute to former Chief Justice Chan Sek-keong was made in Parliament today. Delivering a ministerial statement, Law Minister K. Shanmugam described CJ Chan as being a firm believer in the rule of law and the duty of the court to uphold the law. Former Chief Justice Chan retired last Tuesday. Mr. Shanmugam said CJ Chan's tenure has strengthened the rule of law in Singapore. At the same time, also cemented his place as one of Singapore's greatest jurists. Mr. Shanmugam recounted CJ Chan's early life from humble beginnings in Ipoh to his rise in becoming judge, attorney general and finally to his appointment as Chief Justice in 2006. The Law Minister said his appointment was received with great enthusiasm by the legal community.
Chan Sek-keong, the Chief Justice, was very much like Chan Sek-keong, the man. Humble, unassuming, with a powerful intellect and with a keen sense of integrity. Outside of the courtroom, he demanded that lawyers meet the highest standards of professional conduct, and he took decisive measures to safeguard clients' monies from errant lawyers. He constantly encouraged the legal fraternity, from senior counsel to law student, to do more pro bono work, to improve access to justice for the less fortunate amongst us. And he emphasized the need for competent advocacy in all areas of litigation.
In question time, the recent case of ASEAN scholar Alvin Tan came up for debate. In a strongly worded reply to MP Lim Biao Chuan, Education Minister Heng Swee Keat called the conduct of Alvin Tan reprehensible and unbecoming of a scholar. The NUS scholar had posted sexually explicit videos and photos of himself and his girlfriend on their blog. Mr. Heng said his ministry does not condone this and he is confident that NUS will take the matter seriously. Mr. Lim had asked about the selection process for scholarships. The minister said despite the best care of judgment exercised when panels select individuals, lapses do occur. But it's important that proper disciplinary processes be undertaken. Last week, the NUS Board of Discipline concluded that Alvin Tan's inappropriate conduct was detrimental to the reputation and dignity of the university. While Alvin Tan has been notified of this decision, NUS said all matters relating to NUS disciplinary proceedings are confidential.
Punishments that are meted out to specific cases are governed by statutes and governed by what is in the NUS statute or in the university statute, and therefore we must respect what is done.
With regard to NUS's statutes which govern how it disciplines individual cases, I think there is some concern why in one particular case NUS came out with an explanation as to the disciplinary procedure that it had decided to proceed against with. I think it was a PRC student who made certain disparaging remarks about Singaporean, but in this case NUS has decided to not reveal those what disciplinary action had been taken against another student. So would the MOE consider getting some clarity from NUS as to will there be any consistency about this, the interpretation of these statutes?
NUS has earlier explained the position in that in the earlier case, NUS has sent out a circular, an internal circular to its students, warning the students about the severity of making inappropriate remarks, and in that context, had made mention about what happened to particular students. So these are two different cases, because the statute and the way the NUS has been dealing with disciplinary offences is to ensure that sufficient measures are put in place to safeguard the integrity of the proceedings.
Stricter academic requirements for the School of the Arts as compared to the Singapore Sports School. That's because the two specialised independent schools have different aims. The Acting Minister for Culture, Community and Youth, Lawrence Wong, says that while the sports school is to nurture competitive athletes, graduates from the SOTA may not necessarily go on to be professional artists. Currently, students from all academic streams can be admitted to the Singapore Sports School. However, primary 6 applicants applying to SOTA are required to qualify for the express stream. Mr. Lawrence Wong added that SOTA students will sit for the International Baccalaureate Diploma Programme, which is academically rigorous.
The School of the Arts, or SOTA, was set up as a 6-year true-train program to develop students who would go on to provide creative leadership in their chosen field and become champions of the arts, whatever their eventual profession. While SOTA students benefit from a rigorous 6-year arts education, the curriculum is intended to provide them with a wide range of options for admission into tertiary institutions of higher learning, and not necessarily a professional arts pathway.
Mr. Wong also touched on how the new ministry that he heads will provide more opportunities for people, including youths and students, to participate in sports. He gave this assurance and said this will be through the Vision 2030 program, which aims to use sports to build closer community ties. Mr. Wong said sport can contribute to building a society based on mutual respect, understanding and care, and foster a deeper sense of national pride and national belonging.
Our efforts in encouraging community involvement in the sports will not dilute the focus on high-performance sports. On the contrary, the broader the base of sports participation, the better our chances of developing talented youth athletes. At the same time, the achievements of Team Singapore athletes will inspire other young people to pursue their passion for the sports, whether at the recreational or competitive level.
Malay students are doing better at national examinations. Many are also going further in their educational pursuits. Senior Parliamentary Secretary for Education Ministry Hawazi Daipi said this in Parliament in response to MP for Choa Chu Kang GRC Zaki Mohammed's question. Mr. Zaki had asked if the performance of Malay students are lagging behind those of other ethnic groups. He also asked if the gap is a result of factors such as proficiency in English language, its use at home, socio-economic background and cultural differences. Mr. Hawazi said the factors affecting the performance of students are complex and multi-dimensional. He pointed out that proficiency in English and socio-economic background are contributing factors and are not unique to Singapore. He added that home support and individual motivation also play a part. Mr. Hawazi said the ministry has put in place learning support programs to help not just the weaker students but also the low-income ones, and this has paid off.
Today, close to 88% of the P1 cohort of Malay students are admitted to post-secondary education. This is a significant improvement from the 75% 10 years ago. Although this is lower than the national statistic, the gap has narrowed steadily. This is the result of concerted efforts of the self-help groups, or the SHGs, other community organizations and parents working in partnership with schools and MOE.
The Traffic Police is working with the Education Ministry to review and develop age-appropriate road safety education schemes. In January and October this year, fatal road accidents involving children occurred along Sembawang Drive outside a primary school. Traffic Police, or the TP, recently conducted daily observations of the road over a 10-day period to determine if the area needed further safety measures to be implemented. Senior Minister of State for Home Affairs Masagos Zulkifli gave these updates in response to MP Lim Wee Kiap's concerns on road safety around school zones.
The authorities take road safety around schools very seriously and will engage local stakeholders. We will look at issues of specific concern that the member wish to highlight, and the relevant agency will take it up. TP will continue to send letters to parents of school-going children to raise awareness of road safety messages.
Moving on to the issue of censorship, the Media Development Authority, or MDA, consults the film's consultative panel when classifying shows that may be potentially contentious or when there are complaints received about previously classified films. But Communications and Information Minister Yaakob Ibrahim said it is not possible to consult the panel in classifying more than 13,000 titles yearly. He was clarifying how the film Sex, Violence, Family Values got its final not allowed for all rating. Dr. Yaakob said 20 out of the 24 members of the film's consultative panel, or FCP, felt the show had comments which were offensive and demeaning to Indians. So in view of overwhelming sentiments to disallow the film, MDA decided to revoke its previous M18 classification.
This is an isolated case. In practice, the FCP has not, after reviewing cases referred to it, reached fundamentally different conclusions from MDA. The MDA will continue to evaluate the treatment of theme, content and context when classifying films, and this includes recognizing that satire and parody should not be interpreted literally. In classifying films, the MDA has a delicate task of balancing the interests of different segments of society who hold diverse and opposing views.
On the topic of defence, Defence Minister Ng Hen provided Parliament with the assurance that Singapore will still have an effective military force despite declining birth rates. Dr. Ng acknowledged that an ageing population and declining fertility trends mean yearly enlistments of soldiers are expected to gradually taper to about 15,000 yearly, level seen in the 1990s. Enlistments reached a peak of about 21,000 in 2011 due to past cohorts of baby boomers. But based on long-term projections, Dr. Ng said Singapore will still be able to mobilize some 300,000 soldiers till 2040. He assured that the Singapore Armed Forces, or SAF, will continue to invest in advanced technologies to sharpen its capabilities.
Beyond investing in technologically advanced platforms, we also leverage on technology to network our platforms together to provide us greater synergy in training and operations. So one example is the recently inaugurated Community for Command, Control, Communications, Computers and Intelligence. Another important factor driving up the overall capability and productivity of the SAF lies in the rising quality of our servicemen. Our servicemen are more educated now and also more technological savvy and able to train more effectively.
Questions also on manpower issues. The Manpower Ministry has encouraged employers to consider converting contract employees into permanent staff. The Ministry's Senior Parliamentary Secretary, Hawazi Daipi, said companies should do this if such employees are found to be suitable for the job and if the job is expected to be available on a permanent basis. Mr. Hawazi was responding to a question from Labour MP Zainal Sapari, who wanted to know if the Ministry has plans to give more employment rights to low-wage contract workers. He noted that contract workers may feel that they lack employment certainty and job security due to the short tenure of their contracts. While they are protected under the Employment Act, they might not be eligible for certain benefits such as annual or sick leave if they do not meet the qualifying period of 3 months due to breaks in contracts.
We are working closely with our tripartite partners and our stakeholders to review the Employment Act. At this stage, we are considering suggestions and feedback on various issues, including the protection of low-wage contract workers. Ultimately, we wish to ensure that the Act safeguards basic employment standards to those who need it while still giving employers sufficient flexibility to manage their businesses. We will be sharing more details in due course.
260 employers were found to have contravened the limit of overtime work between 2008 and 2011. Acting Manpower Minister Tan Chuan-Jin gave this update in Parliament. Mr. Tan said 56 of these employers were issued composition fines by the ministry, while 21 were prosecuted in court for more serious breaches of the limit of overtime work. For the remaining cases involving mainly minor technical breaches, warnings or advisories were issued. Between 2008 and 2011, an average of 310 employers applied for exemption each year, of which some 270 were approved. Employers are required to reapply when the exemption expires if they wish to continue to be exempted.
MOM recognizes that in many instances, overtime pay forms an integral part of the low-wage workers' wages. This is particularly the case for some industries, such as the security sector. Now, long working hours may be neither desirable nor sustainable in the long run. To address this, we are in the process of working with the various stakeholders, including the unions and industry associations, to see how we can uplift wages and reduce overtime hours where they are excessive.
The Health Ministry plans to expand the annual intake for nursing and encourage more mid-career conversions to build up manpower in the healthcare sector. This comes as the government plans to build 105 elder care facilities over the next 4 years. Speaking in Parliament, Minister of State for Social and Family Development Halimah Yacob said the government will also work with elder care service providers to raise productivity through initiatives such as bulk procurement, process redesign and the use of technology. And for facilities such as senior activity centres, the government will also explore reducing the demand for full-time workers by encouraging retirees and homemakers to work part-time as home visit assistants.
I would like to ask MOS, what other measure will the ministry be looking at to attract more locals to work as a senior care associates.
We intend to enlarge the scope of work of the senior care associates through skills upgrading so that they could do a lot more work after the skills upgrading through the WSQ. Second, we intend to deploy the use of more technology, assisted technology. That also reduces the tedium and the menial part of the work associated with taking care of the elderly.
More doctors are participating in the government's Community Health Assist scheme since it was enhanced in January this year. Health Minister Gan Kim Yong told Parliament that there has been a 20% increase in the number of participating GP and dental clinics to the current 794 clinics. More patients have also jumped on board the scheme. Mr. Gan said over 220,000 Singaporeans are in the scheme, a seven-fold increase from about 34,000 before it was enhanced. The scheme was improved to benefit more Singaporeans, especially those with chronic conditions. This is through lowering the age criterion for the scheme from 65 to 40 years old and relaxing the income criteria. The government is monitoring the impact of these enhancements and will review the scheme again in due course. The enhanced scheme has also eased patient volume at the polyclinics.
As far as the number of patients are concerned, we see beginning of this year, the first 6 months, we have about 31,000 patients already make use of their CHAS cards in our various private clinics. So that shows that these are potentially the patients that could have been treated at the polyclinics. So now they are going to our GP clinics. We hope to be able to reach out to more.
Now, the Housing and Development Board works with supervising ministries of voluntary welfare organizations in decisions regarding the allocation of void deck areas to such organizations. However, it takes into account inputs from local town councils and grassroots leaders. Parliamentary Secretary for Ministry of National Development, Dr. Maliki Osman, said this in response to a query by non-constituency MP Lina Chiam on the role of town councils and MPs in approving the use of community spaces. Recently, a VWO had applied to use a void deck in Potong Pasir to run a wellness centre where former Potong Pasir MP Mr. Chiam Si Tong held his Meet the People sessions. The new centre is expected to be up by the first quarter of next year.
I want to emphasize that SPP is not unhappy that Block 108 is taken by VWO for residents' welfare, but rather residents should be consulted and explained about the void deck being taken over.
On whether we consult the residents, whether we engage the residents, I think the process ought to be one of engagement. But at some point in time, the decision will have to be made to serve the larger community.
Parliament is debating amendments to the Misuse of Drugs Bill, which gives courts more discretion in meting out the death penalty for drug offenders. Judges can deal a life sentence in place of the death penalty under specific conditions. This is when a drug offender has been proven to be merely a courier and the person has been certified to have substantively assisted authorities in disrupting drug trafficking activities within or outside Singapore. The courier can also be spared the death sentence in view of mental disability. With the changes, it is also now an offence to arrange a gathering where drugs are to be consumed or trafficked. Amendments will also see the introduction of hair analysis to detect drug consumption.
Today, Singaporeans enjoy a safe and secure environment because of our firm stance against drugs and crime. We have long taken a zero-tolerance approach against the drug menace. The amendments proposed in this bill will strengthen our ability to do so in our new operating environment and allow us to continue doing all we can to keep our streets safe and protect our children from the scourge of drugs.
Now, while members of Parliament generally welcomed the amendments to the bill, which has yet to be passed, they had many concerns. MP for Momain Kallang GRC Edwin Tong pointed out the number of drug abuser arrests have gone up in recent years. What's more troubling, he said, the rate of increase has been faster. Abusers have also become younger. Mr. Tong said regional and local statistics show that Singapore is at a 5-year high in terms of drug seizures, supplies and drug abuser arrests. deaths. Coupled with a worsening regional drug situation, he is concerned the amendments which come now send out a message that Singapore has had a fundamental rethink on its strict anti-drug philosophy.
There are already some international publications out there which report this move as a relaxation of our hitherto strict laws, which is a fair enough point. But there are yet other commentators who regard this move as a step in the right direction, except that they say that they regard that direction as being one where the death penalty should eventually be abolished altogether for all forms of offences, drug offences. This latter comment, sir, is not sustainable, particularly in the context of the drug abuse and supply landscape as we now see it. Strong deterrence with the most harsh punishments must still remain a cornerstone principle for our drug enforcement regime.
The alternative sentence of a life imprisonment instead of the death sentence may be misperceived by the general public, especially among our young or by unscrupulous drug traffickers, that they can be opportunistic when it comes to drug trafficking because of the proposed amendments to the Act. The less informed may think that the drug trafficking offence has become less serious, while the opportunists may think that they can get away with a less harsh sentence.
Delivering an impassioned speech, MP for Holland Bukit-Timah GRC Christopher D'Souza agreed with his fellow MPs about the need to remain tough on drug offences. He warned that the criterion of mental disability must be construed strictly to prevent abuse.
If loose interpretations of mental disability are allowed, a legal case may boil down to a fight between the psychiatrist for the prosecution against that for the defense, with the judge being forced to weigh one psychiatrist's assessment over the others. We need to pause and realize that a distinction must be drawn between diminished responsibility in the context of murder as opposed to drug trafficking. Killing can be a spontaneous act. Drug trafficking is often rational and calculated.
It will probably take some time for the courts to develop the jurisprudence on how the diminished responsibility defense that was used in murder would, apply in the case of drug offenses. For example, in relation to murder, diabetics who have not taken their medicine could qualify for the defense, but that may not be the case where the person is a drug mule.
Other MPs also touched on the extent of prosecutorial discretion.
Giving the sentencing judge no discretion in the sentence is undesirable, as the case outcome is determined by the choice of charge, which vests in the public prosecutor. Discretion is thus pushed upstream. Moreover, unlike a judge's decision, which is reached in open court, reasoned and subject to appeal, the public prosecutor's decisions are opaque, not reasoned in public, and unappealable. As it stands, sir, the inherent discretion of the public prosecutor is already very wide. Retaining the mandatory death penalty arrogates to him the additional discretion of determining the punishment the accused should face, which is not his role. It also emasculates the judges, whose role it is to mete out justice based on the facts.
What will happen if an accused person claims he had rendered his fullest cooperation, but the particular CNB officer chose to not recognize it or not value it? What happens if an accused person says he's a mere drug mule and did not have any information on the ringleaders, although he was willing to cooperate fully? Can the Deputy Prime Minister consider how we can make this requirement of substantive cooperation more objective and seen to be less subject to the judgment or discretion or even the whims of individual officers in the CNB or the AGC?
The debate on the amendments to the Misuse of Drugs Bill will continue on Wednesday. An amendment to the Computer Misuse Act was tabled in Parliament today. This is to strengthen the government's ability to act against cyber attacks. The amendment will enable the minister to direct a person or organisation to take measures necessary to detect a threat made against a computer or computer service. This includes requiring a person to disclose information necessary to identify, detect or counter such a threat. Other bills introduced included an amendment to the Stamp Duties Bill, an act to amend the Economic Expansion Incentives Bill, and an amendment to the Payment Systems Oversight Bill. And moving a motion for the adjournment, nominated MP Teo Seong Sing championed the cause of small and medium-sized enterprises. Speaking only in Mandarin, Mr. Teo said, in the climate of a slowing economy, the wish list of SMEs includes the easing of the foreign worker policy, rental subsidies, and a review of grant criteria offered by government ministries and agencies. He said the difficulty in hiring Singaporeans and the tightening of foreign manpower quota are causing a dire shortage of workers in some companies. He acknowledged that SMEs should try to increase productivity, but says more time is needed. In response, Senior Minister of State for Trade and International Development says the government is paying close attention to the needs of SMEs.
My colleague, MOS Teo Serlak, is currently chairing a review effort to ensure that our strategies, schemes and programs remain SME friendly. The review will consider ways to streamline existing schemes and simplify application processes and reimbursement procedures. MOS Teo will announce the recommendations when ready.
Parliament will sit on Wednesday after the Deepavali holiday. Good night.